These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
Alrighty. Today, or this weekend, we will be covering comprehensive administrative processes. I mean, we're going to go into a lot of details around private contracting. Because of that, we want to give a firm foundation in the private-public trust so that you have a clear understanding of your role in your relationships with the parties you're contracting with. It's absolutely essential to mastering your process. So what I want to go over maxims and the private-public trust. Is there a preferred order?
Yeah, why don't we go ahead and get them started with, we'll let you take it over and maybe introduce a little bit more and getting your orientation, so when you start talking about public and private, you might have a little better understanding of it. Who are you? Because Jack and Brandon and I have talked about that extensively, and until you know who you are, besides just giving lip service, I'm me, I know who I am, do you really know who you are? But who is you? We had a talk last night. Alina, come up here, would you? We have here a 10-year-old who's very interesting, and she's been doing some studies with her father. And her discussion is, we had a little discussion last night, so we might ask. I'm going to ask you, who are you?
Why do you want to ask me this question?
I just want to know who you are.
I'm Alina.
Are you sure? Do you have a social security number? Or does Alina have a social security number?
Alina alone has social security number.
And does Alina have a name? Or do you have a name? Or do you have a lot of names?
Well, I have a lot of names.
Ah, there it is. And in the most basic sense, who are you? Can you help me with that? It's like, who are you? Are you that spirit in this body?
Yes, I'm a free person.
Aha. Okay, thanks. Go ahead, sit down. Not trouble. It's important for you all to get. Try and put it in some basics. We sometimes open up, or I speak with my students and I say, I don't know if you can answer these 4 questions. Who you are, who you aren't, where you live, and what your country is. I talk to a lot of lay people this way. So if I say, who are you? Well, let us get this down. We need you to get some basic materials to work with, everybody out there. I would highly recommend you get a Webster's 4th College Edition, get a Black's Law Dictionary, preferably a 4th, 5th, or 6th, and a current 9th. A little bit on a UCC book, and a contract book. Those are at least some fundamentals for you to get a grasp of this. Now, who are you? And you have to really get this down. When this body dies, is it not true that there is a spirit inside here? For those of you that believe in God, that when this body dies, there's a spirit and it goes someplace. Are we in concert with that? So, in reality, is this me? Or is it the spirit inside this body is me?
Are you sure it's inside?
Well, that's a good question, too. But this body is not me, is it? I'm the spirit. So if I ask you who you are, just like God answered to Moses, I am that I am. I'm me. If I want to know how you're called, I might say, what is your name? Or what is one of your names? Usually a judge just wants to know your name. Needs you to identify this body, this collateral.
What are the purpose of names?
What is the purpose of a name?
Anyone have an idea of what the purpose of names are in commerce? To differentiate. Why would we want to differentiate? Well, why? Why do I need to give this? Liability, one reason.
The name binds you to a contract.
Titles, right? Rights, interest. So you have liabilities, duties, titles, rights, interest. That's what gets associated with a name. Okay, you've heard of people just making distinctions between the all uppercase name and the upper lowercase name. Are you either of those? They're just two different forms of title, of identifying interest, of identifying liability.
Also referred to as an appellation or a calling out. How many Brandons, how many Gordons, how many Jacks are there?
And in fact, in commerce, a private trust is a natural person. Look up natural person in your law dictionary. Because only a natural person can contract to create a public trust. What does that mean? It means there was a private trust first. That the public itself is created out of trust. Out of private contract came the public contract, the public trust. So, private contract is the highest form of law. So you want to know, well, how is it we can do these things? Because you say so. Because you have the capacity to contract privately. Nobody can stop you from contracting. No one can impede your rights to contract. And it was private contract that created the government itself. So the government is a result of private contract. And it cannot impede another private contracts. In fact, it can't recognize private contracts. That's why when you go into a court trying to be the private trust, they can only recognize the public trust. My battery's dead.
Here.
The battery's dead.
So let's go forward with the thought.
Well, let me put it down. What we're doing is showing you that if you're lost, the first thing you have to do is orient yourself. What direction do we see the orient as in? The east. But yet in Scripture it says to go west. So you go to the orient, which is east, and does the public really end up explaining who you are? The public doesn't tell you the truth. So where have to go in order to really get oriented to West Publishing?
West Publishing.
Aren't the law people giving you the remedy and telling you the truth? They direct you to the east for orientation, but when you get there and you do not have the truth, you look up the reality in West Publishing, the law publishers books. Well, it's always happens.
You know, Brandon's talking to you about contracts. It is said that all law emanates from contract or agreement. Therefore, contract is law and law is contract. Or stated another way, contract equals law and law equals contract. Consent makes the law. So we encourage you that whenever you see the word law, you substitute contract, and it's going to help you to understand what you're dealing with. But also understand, and you have to stop and think for a minute. Quit reading all the books and all stuff. Say, stop and think, what would bind all of us together? What gives me the right to be over Brandon or Jack? Or this police officer, or this senator, or this congressman over you? Consent makes the contract. What contract? If you're on the highway, some of you are talking about driving down the highway and wanting to use this commercial process to preclude a policeman from getting in your face too much or giving you a ticket. But you have to start out with the fundamental contracts. Whose car are you traveling in? Or driving? I don't know which one you're doing. You may be traveling, you may be driving. But if you have a state car or a car that has a state plate on it, it's their car. And therefore you require some kind of a license. So when you start arguing with that police officer, which has its advantages and disadvantages, you have heard on my recent Monday night, we had Brandy on there, and he talked about he has no plate on his car at all, and he's all the time getting dealt with the police department. I said, why don't you put a private plate on it and identify it? Otherwise, it's merely a pirate on the sea of commerce. He could preclude, but he's kind of having a lot of fun. He's doing some really interesting things with it. But Brand is talking about contracts. Let's keep focused on that. The Constitution in Article 1, Section 10, Clause 1, in pertinent part states that no state shall pass any law impairing the obligation of contracts.
And now, I want to make a distinction there. Your rights do not come from the Constitution. Is everybody clear on that? You don't need the Constitution. The Constitution limits what the government can do. They cannot impede your contracts. The Constitution can give you the right to contract. You have that, it's an inalienable, God-given, absolute right.
Yeah, where do your rights come from? Those that quote the Constitution are in big trouble because you weren't a party to it. That document limits the federal government by the 17 enumerated powers in Article 1, Section 8. Then you say, how does the government do all the stuff they do now? Well, understand. It's a de facto government in a democracy. De facto, existing in fact, but not legally established. Well, that's not right, is it? Sure it is. All these people in America have every right. Every one of you sovereigns, which is nothing more than authority, every one of you creditors, every one of you secured party creditors, every one of you are creditors. That's why you're able to enter into a contract. That contract can be part of the democracy where you give up you can't give up your unalienable rights. They are always there. They're not unalienable, not in a lienable condition. They're God-given, and the only one that can take them is God. But you can't contract them away. And in this world out here, we have two forms of government. We have the republic, which is, in its simplest form, is a limited democracy, limited by the 17 enumerated powers in Article 1, Section 8 of the Constitution. And that is an agreement among the states. When they say we the people, they're not talking about individuals out there. We the people, as representatives of the state. And you can find that elucidated in detail by Abel P. Upshur on a treatise regarding the federal government, which is just phenomenal. So in this thing called contracting, understand that you are the ultimate authority. Your problem, what is your problem?
I don't have a solution.
But if you have a problem, what is your problem? Is it not you?
Yeah.
Your problem, ladies and gentlemen, and we'll talk about this, and we have such good stories to tell you regarding this, so that you can remember some parables, if you will, not parables so much as stories of examples of people that have just given it up all the time. Believe it or not, you know, Brandon has a wonderful story. I have some. Jack has some that happened to each of us personally, as well as many of our students. You're going to find that you are the law. Out here in this democracy, 300 million people existing in this society have the right to choose a democracy. And then there's a very small few which have a right to choose the republic. Really, everybody does, only a small few. I'm on the plane, I'm sitting with somebody, and we're talking about republic democracy. I said, I'm sitting in the republic, you're in the democracy. You think you're John, I think I'm me. All sorts of little nuances. But once you get this down, you're going to find that you have the power. Consent makes the contract. Then we're going to have to talk about it a little bit, because Brandon is going to show you, and Jack's going to show you in depth how to get a contract. At least a parole contract, which can be either written or oral. But once you've got that, how are you going to keep it? That's many of everybody's problem. You can come here to these seminars, be taught how to efficiently obtain an agreement or contract, if you will. But how do you hold it? But more important, how do you give it up?
Let's back up for a second. Gordon's right. Everything is contract. But we know under contract law that certain people do not have the standing or capacity to contract.
Like who, Jack?
Those who are incompetent.
What do you mean by incompetent?
Incompetent means that they don't know who they are and what they're doing.
I heard incompetency was not capable of handling one's own business.
Correct. And so the real question is, what binds us all together? That was the most fundamental question, to which the answer is contract. But what really binds us together is being your brother's keeper. And so if your brother doesn't know how to contract, what binds us together then is necessity to protect your brother.
Are you not talking democracy here for a moment?
The majority of the problems everybody has is they think they're competent and they can go out and handle their affairs. And they run up against someone that is a higher level of understanding in what we call the government.
Put it in a little more simple terms for me.
They won't let you get your way. And the reason they won't let you get your way, and you're saying, but Gordon told me I have the right to contract. You do have the right to contract if you're competent enough to know how to contract, because you are protecting your brothers. When you contract, in which you want to take stuff away from your brothers, or it's all about what I'm going to get out of it, not what I'm doing for someone else, you've demonstrated that you're incompetent. And when you're incompetent, somebody is going to prohibit you from contracting.
So you're saying,
and that's when you get frustrated.
If I try and take this process of administrative process on, and not using good faith, which I heard that good faith is imputed into every contract.
It is. It's not that they can prevent you from contracting. It's that by the nature of your contracting, you're voiding your own contract. You're creating a
Wait, what?
a non-executable contract.
Explain that in a little more detail. You lost me.
We were actually, one of the things I want to go into are some of the maxims of law. Maxims of law are, if you look up a maxim, it's an axiom. It is a self-evident truth.
Okay. I was curious what it was.
The Bible is basically the foundation of Western law. Okay? You'll find a Bible in every courtroom. And in the Bible, you will find the maxims of law. And maxims of law, like you've heard, how many of you have heard silence is agreement? You heard that? Why is that so? Anyone know why that's a maxim? That's an axiom? That's a self-evident truth? How is that a self-evident truth?
Wait, what'd you say?
Silence is consent or agreement.
Seems,
But how, okay, now that's a judgment, right? Disrespectful? That's my opinion. I consider it. Okay, so what makes it a self-evident truth that silence is agreement or consent? It was not rebutted. How can it be presumed that it's against, that you're, how can I presume that you're not in agreement if you have not expressed that you're not in agreement? I can only presume you're in agreement because there was no expressed refusal or rebuttal. That's why that maxim of law is a self-evident truth. When you start forming contracts that violate these self-evident truths, the contract's void. It has no force and effect. So there are certain elements that must be present in order for it to actually be a contract. There must be parties. And you hear a lot of patriots, they'll go in there and they refuse to take any kind of responsibility in connection with the contract. So there's no contracting party there. And if there's no contracting party, no contract. So you have to understand that your conduct in all of your affairs determine whether or not there's a contract. And that's why so many of these patriots in court are getting phoretic hearings.
hold on. You said conduct. I mean, does that mean more than words?
It means a lot more than words. Your
Help me with that.
actions, signs, everything.
Kind of give me an example of what you're talking about.
For example, if I say, sit down over there, and you sit down over there.
So you're the judge. So you're the judge of the
It doesn't
case.
matter whether I'm a judge or bailiff. If I just say, well, you sit over here, we've created a contract.
You
And
give me
there's a
more.
relationship, and by your conduct, you've established a rapport with me. Great example.
Wait a second. I'm just a team clerk. Go slow down.
Okay.
So if somebody tells me to do something and I do it, I've established a contract essentially.
You've established an understanding, which is the basis for. See, a contract has elements in it, and within the contract there can be multiple agreements. Many people think that an agreement and a contract are synonymous, and they're the same thing.
So you're saying that within a contract, an agreement is just the terms and conditions
It
of
could
a
be.
contract. So a contract's the entire
It includes-
agreement of the parties.
And not only does it include the agreements of the parties, which could be multiple
So
agreements.
multiple agreements. Sit over there, do this, and I might change it. It might change. Go back and forth. And that's what's going to. All these different agreements will constitute what we call a contract.
Plus the duties that are created by the agreements, the liabilities.
Yes.
The performance itself is part of the contract,
So the contract really speaks to the whole thing,
the whole thing,
as opposed to agreements, which might be just pieces of the
pieces
contract.
of the contract.
Okay, well, I need that kind of.
Yeah, and actually if you go into the UCC does a beautiful job of making a distinction that contract is not agreement and agreement is not contract. That a contract may have several agreements within it, but a contract will also include the duties, the performance, the liabilities, anything that is created as a result of the many agreements that go into a contract. For instance, a contract could be, I want to hire this gentleman to come repair my roof, right? So I agree to pay him $2,500. He agrees to repair my roof. And now, that is just the expressed part of the contract. What's implied?
Good work,
Good faith in the contract.
do a good job, those kinds of things. completed,
It's
timely, all that.
probably implied that he's not going to do any further destruction in my house.
Right?
Right? It's probably implied that I'm going to pay him
Wait a
in
minute,
some
so
form.
implied, so contracts are express or implied. So when I might make an agreement or a contract with someone, I might verbalize, express something, but then there's all sorts of, you're talking about implied. What do you mean implied?
Implied is, again,
Unspoken terms and conditions you
Unspoken.
understand it to be?
it could be conduct, it could be your understanding in the agreement, the intent of the parties. This is going back to maxims. I love this, one of my favorite maxims of law, and this is right out of Bouvier's. The intention is the soul of the instrument. Meaning, an instrument can be a written agreement, it could be a negotiable instrument, some kind of a bond showing evidence of debt, but anything that facilitates the performance of a contract can be considered an instrument. And the intention behind it is the soul, meaning it's not the expressed words in the document that are the nature of the document. Meaning, you've heard, like, if you meant for the contract to mean one thing, but the way that you wrote it out, it was construed and interpreted as something else. This is when the conduct becomes so important in the contract. I watched an episode of Judge Judy. Anyone ever watched Judge Judy? And the two parties come in, one was a landlord, one was a tenant. And the landlord wanted back rent from the tenant. And they had an expressed written lease agreement where the tenant agreed to pay, in the document, $2,000 a month. But from month one, the tenant only paid $1,800 or $1,600 a month for 6 or 7 months. And now this landlord was attempting to get the tenant evicted for failure, for not paying this back rent. And the tenant's position was, my rent was $1,600 a month. I paid. I am in honor with the contract.
Wait,
And Judge Judy says, well, first the landlord wants to argue and wants to show, here, Judge Judy, this is the contract he signed. It's got his signature on it. Okay? Judge Judy looks at it. Is this your signature? Yes, Your Honor. Okay? She then asks him, what was your understanding of the contract? Well, I understood that I was going to be paying $1,600 a month. I didn't read the contract. Then the landlord, well, it's his duty to read the contract. Right? It's your duty to know what agreements you get yourself into. Judge Judy looks over at the landlord. Did you accept the checks for $1,600? Well, yes. Well, what did you do with those checks? Well, I deposited them. Okay. Judge Judy found in favor of the defendant, the tenant.
did the landlord ever give notice prior to going to court on a monthly basis that the check was short? In that particular case.
Not every month. It wasn't until about 4 or 5 months that the landlord started asking for, what he called the back rent.
Would you say then, in simple terms, that
But a new contract was created every month that the landlord accepted the $1,600, no matter what the landlord was saying. This comes up because people who are working on like their mortgages, their cars, credit cards. You start a private commercial process, right? And so you're establishing a new agreement. And then you receive another statement in the mail. Okay? The statement shows that you owe money. Even though, let's say, you've done a money order, you've done an A for B, you've done a bond and promissory note, you've done some kind of private negotiation with your own money that you created to set off this debt. But now you get a bill or a statement of account showing that they didn't credit you for your private instrument. What happens when you hold on to that statement of account for 30 days? Without responding.
So
You validated the debt.
what you can say in simple terms is, you said the intention is the soul of the contract, right?
The soul of the instrument.
Soul of the instrument. So would it be fair to say that intention or motive is determined objectively?
Absolutely. Judge Judy saw it that way. She saw that it was the intention of the tenant to pay $1,600, that it was the intention of the landlord to accept the $1,600.
What if the landlord, just out of quick curiosity, what if the landlord, instead of just bringing the agreement and nothing more than testifying, which you're not supposed to do for your own case, had brought a monthly statement showing that they were short to $400 each month and it was continuing to accruing? Do you think it would have been a different outcome?
It depends.
Could have been, right?
It could have been.
But the landlord was only in there saying, yeah, I took $1,600 for the last 4 or 5 months, but this is our agreement that was done 4 or 5 months ago with nothing in between, right?
Right.
So, we see this all the time. We see people just alter their agreements and their contracts all the time. It's much like we talk when we kid that Ben Franklin, when asked coming out of the Constitutional Convention back a few hundred years, was asked, what have you given us? A republic if you can keep it. And what we kind of play on that a little bit and say, what have we given you? A contract. Or what do you have? A contract if you can keep it. You say, no, it can't be that hard to keep it. Au contraire. Actions do speak louder than words. And what Brandon's trying to explain to you is very simplistic. Is contracts are just moving all of the time, or they can move.
They're dynamic, they're fluid.
It doesn't mean they are moving. They move what you want. Mortgage companies used to, some of you can recall that for a while there, when you couldn't make a full mortgage payment, you could send in a partial mortgage payment. I'll catch it back up at the end of the month. Or with a car company, I can only make a partial payment. And pretty soon people got wise to that. And they started going to court saying, look, my house payment was $3,000. I sent them $1,500. They agreed to keep that. That's the new contract. And the courts were sticking those people with that. So you often find now the mortgage companies often will not accept any partial payments. So contracts are dynamic. They can move. And they will move. On what basis will they move? Because this is going to go to the fundamental of what he's talking to you about. What you keep doing, or what many of our students, friends keep doing, is they keep moving the contract. We had a recent guy that was staring at being in federal prison. And this gentleman, we had gone in, done a fair amount of paperwork, and submitted something back May 20th, the day of sentencing. And he was looking at getting 5 years or so. He's a basketball player out of California, dealing with some OID money problems. He's in jail for that. And we put forward some things. It was like over $5 million, and he spent half of it. But he wouldn't tell him where he spent it or whatever. The long and the short is, he was going to be sentenced May 20th. We put in something that said we wanted to fix. We were going to go back and fix the civil dishonor that was done with IRS regarding that. And the judge made comments, beautiful on the record, that obviously there's a man of honor and integrity in there. We're going to see if there is, and that kind of thing. He gave him 60 days. And we told him, okay, now what you have to do is go back and fix the problem. And instead, he hooked up with this group that will fix things behind the scenes for little or nothing, supposedly. Well, July 8th came, sentencing. They hadn't done a thing. And he hadn't done a thing. And the judge went from being courteous and kind and a good man to, it's obvious that you're looking at some jail time. You've made no effort to do this. He warned this guy up and down, back and forth. They still didn't want to fix it. They had faith in this group that fixes things for nothing, or little or nothing,
And if
behind the scenes.
And if you're looking at, if you espouse the ideas that we espouse, which are that we are responsible for everything that we create, that as creditors, that's something that we take on. These are principles that we live by. That as creditors, we take full responsibility for everything we create. And as such, we don't look for other people to solve our problems. We look to solve other people's problems. We don't have problems. So if I get an IRS statement showing that Brandon Adams owes $250,000, well, I have the opportunity to assist the IRS in settling an account.
I think Jack says it real clearly. Creditors work to solve other people's problems.
And if you're wanting to be a part of something where somebody's going to do it for you, that's what, in my idea, the principles that we espouse, that's being a debtor. That I'm not responsible, I can't handle, I am not competent in handling my affairs. And we're seeing a lot of these people who are hoping someone's going to swing in and save the day and do everything for them. They're not getting the remedies because they're showing their incompetence.
And to finish that story, this guy didn't fix it. He got a 2-week warning. He went to sentencing yesterday. They gave him the maximum they could give him. And they said he hadn't done a single thing to help him do it. At the previous hearing on May 20th, when they said, we need you to pay this back, and he says, you got all my money. Must have had no ink left in
The
his
judge
hand.
said that it appears as though there's a man of character in the defendant.
Integrity and honor.
And so the judge postponed sentencing for 60 days so that number 6 is man times 10 is the law. He can demonstrate that he was a creditor, a man of character. And in that time, after that hearing, well, during the hearing, after the judge said, I'm not sentencing the defendant today, the judge made that comment based on paperwork that he had put in there showing that he was trying to sell off, sell and close everything. But then the judge came back immediately and he made a statement. According to the record, it appears as though you still owe the United States $2.5 million that has not been recovered in the refund that you got from the OID. Are you going to help the United States get their money back? And he looked at the judge and he made the statement, well, you guys pretty much got everything I've got. Does that sound like a creditor or a debtor? And I'm surprised why then the judge didn't change his mind in sentencing, but they gave him 60 days. So when they took him back to jail, Gordon and I learned about this. We told the people on the outside that were the connection that would get information to him that you better be ready because in the next 60 days, they're going to send somebody to your cell and interview you because the judge wants to get a report. What kind of man is in that defendant? Is it the man of character who is going to be a creditor and help, or is it going to be a debtor in there? Because he had excellent paperwork which delayed the sentencing, but then he made that stupid statement that came back and said, you pretty much got everything I've got.
Now, this guy called me regularly, so for the first couple of weeks, when he did that and I heard that, he said, no, I know that was stupid, I shouldn't have done that.
The judge had 3 visits sent to his cell in the next 60 days. The first one was an investigator which came and just informally was saying, well, would you like to help the United States get that money back? Well, if you understand you're a creditor, you're going to do a full acceptance, and if you haven't done it before, you're going to authorize a set-off with your asset account. And it's a done deal. It's history. But he was going with things like, well, is the court going to give me an order to work with the United States?
Are they going to order me?
And the investigator's going, no, we're asking if you're going to help us with this. And the guy is going, well, if they're not going to give me an order, I'm not going to volunteer. a man of character, a creditor, a debtor? First time. That's what he said. They went back and, whoa, this isn't going well. Came and visited him a second time. Same thing again.
With a witness this time.
And he blew off the same thing. And the witness, who's now the U.S. prosecutor that went with the investigator, that gave him the opportunity, he changed that.
You can see how this is an example of conduct changing the contract. You know, a lot of people out there will fill out documents thinking that that's going to make them a creditor. You know, if I fill out a UCC-1, if I fill out a security agreement, that makes me a creditor. You know, your conduct makes you a creditor. And in this case, this gentleman had documents that identified him initially as a creditor, and then could have conducted himself as a debtor over and over again.
Problem is, we gave him those documents. So, he might have been a creditor had he adopted the stuff that we'd given him, and he had a copy of it. Well, let's let Jack finish the story.
The third time that he was involved with the court, he was in front of the judge. And that was yesterday for the sentencing hearing. And Gordon called up his friends last night because we went online to see if the court had put anything in the docket sheets yet. And they had not, but one of his friends called back. And these are the people that have been kind of ignoring Gordon and I for the last 6 weeks. It was after we had helped him put the paperwork in, which got the judge to say there is a man of character that might be in that defendant. They elected to go with someone else. And they haven't told us who, but we believe it's the ones that are promising, well, you don't have to do anything. We'll take care of it for you. And so, oh, I don't have to do anything. I can relax. My future is secure. Is that a debtor or is that a creditor? Because if you are incompetent to handle your own affairs and you've given it to someone else,
Again,
you are a debtor.
Again, competency, capable of handling one's own business.
Capable of understanding contracts and being able to move the contracts, not only to settle your problem, because your problem in the contract doesn't go away until you settle their problem in the contract, which is why you were involved with them.
Part of the contract is offer and acceptance.
That's correct.
And they
But
got offered,
performance.
and he got offered to pay the 2.5. We need the 2.5 million.
We need performance. If you're going to be a man of character and go home instead of going to prison, you need to help the United States get the $2.5 million. Now, this is not an issue dealing with whether OIDs are valid or not. That was not what was in front of this court. What was in front of this court is that this guy got brought in on an alleged charge that he didn't do something right, and he never rebutted the charge. So since he failed to rebut the charge that he did something wrong with an OID, under the maximum law, failure to rebut it means you agreed you did something wrong. So what this is about is fixing the wrong you agreed that you did, even though it probably wasn't wrong. So it wasn't about whether OIDs are valid or invalid. It's about the fact that he never rebutted what he did being okay. So he had a duty and an obligation, or he's going to prison, and he would not fulfill the duty and the obligation. So he got sentenced to the maximum, because for 3 times the court gave him an opportunity to come and act in that role and conduct himself like a creditor, and he chose to, well, somebody else is doing it for me. I don't have to worry about it.
We had a comment last night from the person that reported back to me about what happened.
Yes?
And that was a very nice comments they made. Maybe you could elucidate or
There were a lot of statements, and they basically were, well, the court is out of hand. The court is doing whatever they want to give. They didn't give this guy the benefit of the
Just
doubt.
a show, right? Just a show.
Just, yeah.
No, witch
They,
hunt.
they punished him merely because they're using him as an example to stop everybody from OIDs. And it's like, well, now that we see that his friends all have this debtor mentality, it's easy to see where he gets it.
What kind of hunt did they call
A witch hunt.
it? But we know it wasn't the witch hunt because he's a guy, so we know it was a warlock hunt.
That's right. So they need to define it correctly. But the point we're making here is that if it appears as though something isn't working in your life, you are probably not doing it correctly. And the other side has a fiduciary duty to protect someone who is incompetent. So if you're in a commercial scenario and it is not working well for you, it's probably because you've been deemed to be a debtor incapable of contracting to protect yourself. So like Brandon said, you look like you're contracting, but since you do not know what you're doing, you don't have any contracts. And they just invalidate or void everything you're doing. And they're doing that for one reason, to protect you, because it's now an exigent circumstance, it's an emergency, you don't know the law, you aren't applying the law in your life, so the law has to come down and protect you. And when it protects a debtor goes into servitude for a period of time to work off his debt. And that's what we're seeing happen.
It's a critical principle to understand that we believe. The government always does it right. And that's really hard to swallow, especially when you're suffering privations or being attacked as you think it, or you're not handling your offers well. Believe it or not, it's so important for you to understand that simple concept. If you're not getting your remedy, it's because you're not doing something correctly. Now, also, and Jack and I and Brandon have all seen this, it will be principles that it's not what they say, but what they do is really what's going on. Jack and I had a client on a mortgage deal, and she had received a notice to vacate by the sheriff after we'd done tons of work and paperwork, etc. Did that mean it wasn't working? Not at all. It was just another offer. We countered that with a nice conditional acceptance on proof of claim that there wasn't already an agreement attached here to, etc., etc. She's still in the house today. And so, if you have an understanding that, one, they always do it right, but they can test and they can play, and everything isn't always as it seems. You do make the law. They need your consent. A final throw at it. And in that particular case, that was very effective. But if you can get your mind wrapped around that they always do it right, that we're usually the ones at fault, not usually, invariably, we are always at fault when we're not obtaining remedy. And it takes such there's such subtleties involved in it, what constitutes this. It's just going to take all of you a little time. It's not so evident in an express understanding. We've had a couple of our fine students go into court, and they say they do their business and walk out. Boy, they thought they were going to be arrested. They did it right. They walked right on out. Marshal puts his arms up to block him, and the judge says, "It's okay, let him go." And it's such beautiful stories. This government, you're going to find, as a creditor, is the most perfect government on the planet. The republic and the democracy are available to you, and they don't make you do anything, but they will protect you from your own self, and you will not like that. Don? Hold on, let's put it on.
What's the point of warehousing your body when they determine you're a debtor?
What's the point?
They're beating you and giving you a place to stay. What are they getting out of putting you in prison?
Let me answer that. Hopefully as briefly as
That's a good question, by the way. What's the advantage of it? Well, there's a lot of advantage, but let Jack talk.
There is no money anymore. Lawful money is gold or silver coin of proper quantity and quality. But that was demonetized in the 1930s. So either in the republic or in the democracy, there's no definition of what money is.
Well, there's money,
There are
because
things
money is
that
defined
use-
under UCC as the medium of exchange.
It's
There's
something
money, there's not
as
lawful
a
money.
though.
It's a medium of exchange.
Yeah, but it's something you
It's
can
evidence,
ask me money.
right, even though it's an evidence of debt, it doesn't have any intrinsic value, which is typically what people think of money, as being something with intrinsic value. It doesn't have intrinsic value, other than the value that an evidence of debt has. Because we walk around with evidences of debt, we realize the value in them. Isn't a bond an evidence of debt? Or evidence of a liability, or evidence of a duty? In fact, you can sell your accounts receivable to your bank because it's evidence of a debt. It's a medium of exchange. So we use, it is a medium of exchange in that definition of money. Now, it used to be that what we used as money had actual intrinsic value. So if we're exchanging something with intrinsic value, banana, it's got intrinsic value, for gold or silver, which have intrinsic value.
Okay, let me redefine my statement. If it's absolutely true, we're using it as a money, as though it existed. What I'm saying by that is money has both legal and equitable title to it. What we're using as a money represents an exchange of equity, but there is no exchange of legal title anymore. And in a strict definition, money is portable property, which can be exchanged for other property. And so you get what you, quote, pay for, and if you're exchanging only something used as money, you're
Which you
getting
don't have legal title
equity, which means you get equity, but you don't have legal title, so you don't get legal title. And the definition of a sovereign is one who has both legal and equitable title in his possessions. So in 1930, when they got rid of money, they basically made it prima facie that there could be no sovereigns left on the planet because nobody can acquire legal title to anything they acquire. But we're getting off point to your question, why is the guy in jail? The guy is in jail because your body represents commercial energy. Money is the exchange, the currency, which exchanges commercial energy. So the source of that which is used as money emanates in a living body. A dead body has no commercial value because it cannot either by the mind or by the physical nature of the body create, convert, transport, or change any energy.
What about the bonds that are put up?
That's the commercial energy
Yeah.
we're talking about.
Okay.
Yeah, it's part of the exchange of the energy, but in order to invoke the bond, it has to come from someone's authority and permission. And so in reality, it is your signature, the signature of a live human body, which creates that which is a commercial energy or that which is used as a money.
And that bond or instrument only has value when the asset is pledged. So the body, the asset, is pledged. For instance, if I put up a bond with a bank and it's an asset-backed bond, they'll trade these on trading platforms and earn and make more money out of it. But the backing of that bond has to be an asset that is pledged. The interest in that asset is pledged. So you must pledge your interest in the property, the body, to them. Because now that they have an interest in it, they can float these instruments on it and earn more money.
Where did they get the interest in your body?
They get currency pictures.
How did you give it to them?
Voluntarily.
Set up a trust and put it into as the birth certificate to begin with. And then each transaction you authorized it to continue to go into there. So the birth certificate created a trust with all your commercial energy, divesting the living man of the energy of his own body, putting it into this trust. So the birth certificate is a security agreement between the state and the party. And that security agreement, when registered in a public registry system, becomes a claim, a lien, or a title against the body. So if your strawman estate fails to make a payment, let's say on a criminal charge, and the strawman estate is now found guilty on that criminal charge, then there is a duty, a liability, a tax against that estate to set off that charge. Since the body is the currency or the source of the currency, when they deposit a body in a physical location, and the body is money, isn't the deposit of money called a bank? And so aren't prisons banks? And the prisoner in there owes a certain amount of money for which his body, through the registered security agreement, ties him into the contract. And the amount that he owes is like a certificate of deposit. It has a fixed amount, good for a fixed period of time. And so everybody in a prison is in a bank on a certificate of deposit. And that certificate of deposit, those funds, that energy is tied up for a fixed period of time, which cannot be let out in circulation. So you're kept in the prison as though you are a CD on deposit. And what does the banks do with the funding that's on deposit in these CDs? Don't they take that equity out and reinvest it and make money or profits off of the reinvestment of the equity? Absolutely. If you were a banker, that's exactly what you would do.
So while you're sitting in prison,
they're making money off of the people in prison. What does Scripture say at end times? Aren't they buying and selling the souls of men?
You know, you do have that birth certificate and the rest of that stuff out there, and that is a concern to one degree. But remember, contracts are dynamic. When you try and grab me up off the street, bring it forward, if you will. You're not going to do it, so you're going to get whatever you contract for. Somebody brings you a charge, discharge the charge.
Sometime this weekend, Brandon will probably put on the chart the flow of the way things go in commerce. It goes from money or currency to title to possession. And everything they're doing in the court and everything you're doing privately in your administrative process deals in that succession. For instance, you want to buy a home. You don't have money. So what you do is you sign a note. The note produces the currency, but it's produced by the living man.
Slow down,
On the
I like
private
this.
side.
Slow down, I like this point.
He produces the currency. What happens is the bank takes this note and they go, well, we don't want to use private money in our system because if everybody figures out that they create the money, they'll just go down to the grocery store, pick up groceries and leave a note. And then that cuts the bank out and it cuts the government out and nobody's controlling these people anymore. They'll just go out and buy whatever they want on their own notes. But worse yet, they won't be responsible on their own notes to go out and perform any service in society so that their notes, in essence, are hollow, there's no substance, and people will be stealing and the society will collapse. So the bankers go, you know, we're not going to define that note to be a negotiable instrument that's going to change hands in society as a public money. We're going to call it a security. Well, a security agreement is a contract for performance. And if you register a security, it becomes a title, a lien, or a claim.
You know, I like Webster's definition of security, and it helps you to understand it. Any evidence of debt, and it has one other to it, evidence of debt or ownership, especially a stock certificate or bond.
So what they have done now is they've taken your note, you gave it to the public, they don't want to use it, so they sell that security to the public window of the Federal Reserve System and the private DTC, Depository Trust Company, which takes it now as an asset, which is a title, a property, a claim. They then end up creating Federal Reserve notes. In other words, you gave us a title. We're going to buy it from you with money. So the exchange is the DTC got your title, which is an asset at face value of your note. They sent public money back to the bank. So now you created private money, but the bank sold a security which got monetized for public money, which is what they lent to your straw man. Now, when they lend the money to the straw man, what does one do with money? You always use money to buy a title. So the money that went out of the bank that was loaning the straw man to buy the house paid the seller of the house to buy a title. So now your straw man's got a warranty deed.
Hold up, Jack. So when you say, make it more simple, like if I'm going to the grocery store, what am I really buying at the grocery store? Help me out a little bit.
Grocery store is a perfect example. You go to the grocery store, you wheel a buggy through the aisles, loaded up with crap. If you go to the front door and walk through there, you're going straight to prison. What you do is you go to the checkout counter, right? Now, you are trying to purchase title to something, all of the crap that's in the buggy. In order to acquire title when you didn't have it, you got to give them currency. When you give them currency, you're buying title.
Wait a second, so I'm not buying the groceries, I'm buying the title of the groceries?
You're buying title. It's currency, title, possession.
Okay, I just need to get that in my mind.
Okay? Now, what you're doing when you offer the currency at the register, haven't they already scanned the items so that they know these are property items being withdrawn from their inventory? And so they say, well, you know, in order to acquire title to property, that'll be $75.33. So you extend to them currency. What is the next part of the transaction, and what happens? They give you a piece of paper. And where did that piece of paper get printed out of? Register. See? They had title. You were negotiating an exchange, which is a security agreement. But for the security agreement to morph into a title, they have to register it in their records. But isn't that what their computer doing in their registry? Registering the exchange of the contract. You're going to offer me money. We're going to offer you some goods. Okay, there's the agreement. Now, when we record it so that they can bring it out as evidence in their transactions, it's actually the security agreement is registered, moving the security agreement from a mere security agreement into title.
So if I get
Or a
stopped,
claim, or a lien.
so if I get stopped at the grocery store door, I don't say these are my groceries. I present evidence in the form of a title, i.e. a receipt, and I'm going to walk out of there.
They print out a piece of paper from the registry, right?
Right.
And so the clerk is now the first one to hold the receipt, right? Possession is when she gives you the piece of paper. That's possession. The goods that are down here in the buggy are the price, the premium, to induce you to come in and purchase the piece of paper. But that's the only reason you're in the store. You're there for the prize. You're not there to get this marvelous piece of paper. But the point is if you're in a foreclosure, you know, there's a lot of people going through foreclosures, and it's going to go currency, title, possession. When the bank brings the property on foreclosure, either to the trustee or the court, what is the bank doing in that action?
Perfecting the title.
Well, they're selling a title. What title are they selling? Mortgage deed or the trustee?
Well, first they have to perfect that they have the title to sell. So
They should, if the people made them.
Right, but what they do is they get you into an agreement that they do have that title by initiating the action.
Correct.
By initiating the action, you have nothing but agreement with the action. You're agreeing that they have the title. Because in
Well,
fact...
slow down, I'm just a little faster. Slow it down.
I tend to do that. So in fact, what happens is that they're attempting to convey, okay, grant and convey title to the property. However,
Well, who has the title first? Tell me
you
about
have
it.
the title.
I've got the title,
You've
okay.
got the title because you've got the grant deed,
Okay.
or what Jack calls the warranty deed.
But wait a minute, the other deed supersedes the warranty deed, making the warranty deed invalid until the trustee.
First in line, first in time. Which one was established?
But there was a death contract by way of the trustee.
I know that, but that's what we would call an encumbrance. on the
That's
property.
true.
So it's a lien on the property, but it's not title to the property.
Hold on, you're going too fast for me, guys. Slow
Now,
down.
not to say a lien is a form of title, okay? You can have, in one item, multiple people can have interest in that item.
A lien is what? It is not a lien, just a claim on the property.
It is. It's a
of another
form of
as
interest.
security for the
It's
payment
a
of
form
the
of interest, but if
estate.
you read it, everyone whose name is on the document has an interest.
Right.
So there's the bank, there's the trustee, if it's a deed of trust state, and there's the trustor. Okay? So you have three interested parties. All three parties have an interest. Now, one of those parties, the trustor, has another interest that superseded and preceded that. Okay? Now, in order for the bank to convey its interest,
Wait a second. What's the trustor in this
the
relationship?
trustor is the purchaser, the person who purchased the property.
Okay, okay.
So you're the trustor, you create the trust. So again, in mortgage states, there's no trustor, but it's the person who's on the warranty deed. When the conveyance happens between the seller and the buyer, the initial conveyance. Okay? What the seller conveyed to the buyer was their interest. So you have a form of interest that lies underneath the mortgage agreement or underneath the deed of trust. Okay? So you have title and you have possession. When you have those two things, those are very hard to overcome. So what they do is they carry on a series of transactions where they get no rebuttal from you in the transaction, where they're conveying an interest. Now, if all they were conveying was their interest, well then all they would be conveying is a lien right in the property. Because that's all the interest they have, is a lien right in the property. Now, if all they convey is a lien right in the property, who wants to buy that? Especially if it's clear that the guy in the property isn't paying on the lien right,
So a lien
so there's no
right,
value in it. But
so a lien right unto itself is really nothing. It just, you can have a zillion liens on it.
yeah,
It's not
you can have a
building.
lien, yeah. Can you enforce the lien? That's what it comes down to, because you hear about all these people who file UCC-1s on their property, and then what? Nothing. Right?
Okay, Brandon's right in what he's telling you so far, but remember, we're creditors. And what a creditor wants to do is he wants to remove all form.
Oh yeah, I'm not telling you this this is the approach to settling it. What I'm telling you is what's going on is the bank is they give you a trustee sale or a sheriff sale. What they convey is their interest. At that moment, though, nobody wants that interest. However, a trustee sale and a sheriff sale deed, those aren't grant deeds, and they're not deeds of trust. It's a special kind of a deed. How many people heard of a quitclaim deed? Okay? It's just like a quitclaim deed.
Okay, there's no warranty or guarantee.
Right.
It is what it is.
So for instance, Gordon has a house. Okay? I quitclaim Gordon's house to you. What did I just convey? Nothing, because I don't have an interest in Gordon's house. However, I walk up to Gordon, I pin a 3-day notice on his door, I take him to an unlawful detainer, I get him kicked out by the sheriff, now I got possession of the house. What did I just convey to him?
Possession.
possession was conveyed by a document that happened before I got the possession. See, in a quitclaim deed, if an interest is acquired later, that's what's conveyed in the previous document. So in the trustee's deed...
Slow down, hold on, I lost me on that one.
Okay.
Go back just one sentence or two, I like that, tell us again.
Okay, so in the trustee's deed, or the sheriff's deed, what's conveyed is an interest they have not yet acquired, which is possession.
So back to simplistic, it's my house, and you just out over here just came over here and gave it to Don. Okay.
I conveyed it. I conveyed my interest.
Whatever interest you had, which was none.
But which was none. But then, I skillfully acquired possession.
Okay, slow down, keep it going, I'm not with you. Keep
So,
going.
because I skillfully acquired possession, and because I granted and conveyed my interest to Don, the interest that he obtained was the possession that I obtained later. Okay, so in a trustee's deed upon sale and a sheriff's deed, what's conveyed is actually acquired later.
It's just whatever interest you have at this time, if you don't have any at this time, you're gonna go get it later.
Right, and what we'll show you this weekend is, as a creditor, that's the three elements that we approach. See, first as a creditor, we settle the account.
That's currency.
That's the currency side of it. Then, as a creditor, we're proactive in perfecting the title. Because once the account is settled, there's no longer an encumbrance on the property. So we need to eliminate the encumbrance.
So you're still gonna, in simplistic, you're still gonna give Don whatever interest you have in my deal, whether it's settled or not, aren't you?
Yes.
Because you still didn't have an interest to begin with. But you're gonna see if you can't still get it later, right? Okay, I'm with you. Go
And
ahead.
once you've got the title free and clear, you've got ultimate right for absolute possession.
And because you're already in possession, that's not an element you have to perfect. However, some people are in a position where they've lost possession, right? And there's what a lot of states call a redemption period. And even if there isn't a redemption period, it's all contract.
We could not pro-tunk something.
You can non-pro-tunk it, and then so you would go through the process of, you still need to settle the account first. Settle the account.
Wait a second. Settle the account.
Settle the
Just give me
account.
a quick, simple, settle the account meaning.
There's an obligation.
Let me use-
That security agreement he was
Let
talking
me
about.
use the example of the guy that we said was in the court who had a man of character and may not go to jail, okay? What was the judge asking him to do to prove he was a man of character?
Say the IRS.
Settle the $2.5 million, so the court was saying, produce the currency.
Settle, what do you mean settle? Just,
Produce the currency
Bring
to
the
set off the debt.
okay.
Have the guy done an A for B, had he done a bond, had he done a draft, he could have set off the $2.5 million. Now, why were they holding him in jail, and why was he in the court process? Because they had possession of the guy's body in jail, didn't they?
And an unsettled account.
In an unsettled account, and they were using the possession to induce him to make the currency payment.
So liking it to a mortgage,
If he made the currency payment, could they give him a receipt for the debt owed to the United States?
they could.
And would that receipt then recorded in the court be title?
Could be.
And when he released and freed up the title, why were they holding his body in a jail cell? Because he was deposited as the currency to underwrite the lack of the fact that he had made payment voluntarily on the account.
And
So what-
let me demonstrate this for a way that might clarify it with
Yeah,
you
you guys are going so fast. Slow down.
and tie it into the mortgage. Okay? Just like Jack said, there's the account that's settled, right? That account was holding an encumbrance. Let's say that court case, those
Just
charges.
use a mortgage, that's more like.
I'm going to relate it. I'm going to show you how they both
All right,
relate.
all right.
So there's a charge, right?
Okay,
That's the deed of trust.
okay.
Okay? It's an encumbrance on the property.
Deed of trust or charge, same thing.
Same thing.
Right? Okay, gotcha.
The house,
Yeah,
the body.
Okay,
And
yeah.
so there's the charge, the
Yeah.
encumbrance on the body. And there's the deed of trust and encumbrance on the house, right?
Okay, I
You
see,
see how
I
those two
see,
things
yeah,
are
I'm seeing it, I'm starting to
Okay.
see it, okay.
Settle the account first,
Pay
right?
the money
The encumbrance.
So I gotta pay something to settle the account,
Right. You gotta
okay.
pay something to
Pay
settle
the
the
bank
account.
what they're looking for so they won't foreclose, or pay the court what they're looking for to settle the issue behind the
So hold
scene.
on, let me simplify it. So in the court case deal, I gotta get the $2.5 million to the IRS, but if I've got a mortgage situation, and it was originally a $400,000 mortgage, there's $390 left or $400, I need to tender as full satisfaction of the claim, some kind of a financial instrument to discharge the debt.
Absolutely.
Okay, I got it.
And in both those cases, the encumbrances, there was both parties had an interest.
So over here, I can use the A for B to settle, right?
Absolutely.
Okay, just
In both
clarify.
cases.
Okay,
So-
both cases.
both
Okay,
cases.
slow down, slow down.
Okay, so there's an encumbrance on the property.
Got it.
Okay, the title of that, there's the right to possession.
Yes.
Okay,
The sole right.
we both have an interest in the house, right? Both the bank.
Yeah, I do because I signed the mortgage, right, and slow down, and the bank does because they lend me the money, right?
Okay, so there's two parties with
Okay.
a right to possession.
Okay, I got it.
With the body, you've pledged the body as surety on the charges.
Now we're over here talking about the court case. Now we're off that, we're on this
Yeah,
one.
we're on
Okay,
this one.
All right.
Okay, so there's two conflicting rights of possession. Okay, over here, you need to discharge the bank's right to possession
And I do that, hold on, by paying them.
by settling the account and
Settling.
protecting the title.
Okay, so we're just dealing with settling an account first thing.
Well,
Go slow.
once you've settled the account in a mortgage situation, we're proactive in perfecting the title, which you could do over here in the court case.
Okay, hold up, slow down. I understand A for B, I settled the account over here on the mortgage. Let's go to the court case, I'm tendering the $2.5 million, I'm settling the underlying
Okay,
civil.
but understand, Gordon, what you're not looking at, that Brandon's trying to show you, is just because you paid the money, you performed on the contract, but it's a security agreement.
I'm with you.
And in that agreement, both parties have to agree that the consideration, the payment was sufficient to terminate their interest in this contract. So in order to get the agreement in the security interest, you gotta go through a process, which we're gonna talk about this weekend. The end result is when you got the agreement done, you've gotta register notice of that agreement to change the security agreement
Hold on, you-
into a title.
Slow down, let me just get a little bit closer here. Y'all with me? So I gotta get, hey, look, we need inquiring minds want to know. Just because you two are smarter than me, I'm lacking, you know?
Is merely an unlettered mendicant.
That's it. No, seriously,
Yeah,
so
whatever you
I
say.
just need to slow down just a little bit so I can get a little bit better understanding. I do the A for B. Now, I understand we got like section 1, we got settlement. We got section 2, we got perfection of title, we got another issue, section 3, possession. So I'm just going to come over here and want to talk just for a moment about number 1, settling the account.
Your money.
And I've got to do that through an A for B and an ABC process, what we call an administrative process.
Say.
All right.
You gotta do anything that in standard commerce is recognized as a request for an order to move the storage of commercial energy from one account here to another account over there.
Simplify, pay the bill.
Yeah, it moves from your account where you're taking the units out, and it's gonna put it in their account because they wanna get paid.
Slow down. The units, you say dollars, units. but
There
you're just referring
there
to
is no
dollar
real
units.
money, we'll just call them units, because since
Okay.
there's only the game of paying, there's nothing by which to pay, so you play the game as though there was money,
Okay.
and you say, I'm gonna write a check, which is gonna move them from here over there, so you can pay with a check. But if the check is on a public account, removing liability funds, if you can reach behind the democracy into the republic and get what we call asset funds, that asset funds has both equitable and legal title. And it moves not only the equity in the contract toward you, it moves the legal title in the contract to you. And that is something you cannot do in the public because the public does not recognize that you have the capacity to move the legal title. So first they have to understand there's something that you can do, quote, to pay this debt.
But in reality, whether I use my signature and a draft or something I create, an asset-based financial instrument, or I use some liability funds, either one is going to move a title. Whether it
No,
moves
we're not at title yet, we're just moving currency.
Yeah, it's moving the currency. The title happens as a separate process.
Okay,
Here,
so I'm
in
just
the
back-
interest of time, because this is actually what I'm about to say will take me hours of explanation and showing you the actual process of doing it. But in the house situation, we perfect the title by eliminating the encumbrance by doing a series of private process and public filings which eliminate that encumbrance. We do the same thing in the court case, where we do a private process, and then through the agreement established in the private process and the powers obtained, we execute certain documents which eliminate the title that they have on the body. So over here, we would have like a, what do you call it, a full reconveyance, right?
Are we on the title section?
The house, so the house, you have a full reconveyance of deed. You may have, I don't know what it would be called in the mortgage state if they do. Is it called reconveyance in the mortgage state? Is
It'd
it
be cancellation of mortgage.
cancellation of mortgage?
Satisfaction.
Okay, whatever in a car situation, release of lien with the DMV.
I think
Okay.
DMV just did one
With the
satisfaction
court,
lien.
with the court, it's going to be if there was already a judgment, a release of judgment, okay? If we're not at the phase of judgment and we've achieved private settlement, it would be dismissal with prejudice because we've already settled this in private. We don't need to have a public order or judgment in order to settle. We settled it. So, but we need to be the ones proactive in executing the release of title because we're the creditors. We're not putting the duties out there on someone else to execute on our behalf. And if we wait for someone else to do it, it may not happen.
So
and we don't have the right to possession and we don't get our remedy.
In simplified form, that means after I've settled the account, I've paid the money, gone through my process to get an agreement that it's paid, you're telling me we're going to have to go over here and do the title too.
Exactly.
Okay, I understand. I just want to make sure I have that down. So it's not like I'm going to have to be, I'm the one that's got to do all these first steps, all the second stuff, and maintain my possession also, which might take defending against an unlawful detainer action or anything else. So that's what so we got three areas, and we got the one paid. Now you're talking a little bit about title and perfecting the title, getting all of that, the reconveyance, satisfaction of lien, potential revocation of power of attorney, anything else that we're doing in whatever judicial or non-judicial state I'm involved with, right?
Absolutely.
Okay.
And it applies in all cases, whether we're talking about civil court suit, criminal court suit, credit card accounts.
Are you saying
Car loan.
Wait a second. All this stuff,
It's
all these charges are just simply
actually, some of them-
CFR 72.11?
Yeah, some of them are easier because they don't involve property and title necessarily. Like for instance, there's no interest in title in a credit card debt. However, with a car loan, there's a piece of property that's secured by the agreement, and so there is that interest. In a criminal court case, there's a body. There's things associated with the encumbrance and liability. So there's, in some cases, it'll be easier to settle, on others it will not. And actually, we're taking a break, Jeff. You can go ahead and take that. So we're going to take a half-hour break. We'll be back here at 11:15.